With only 20 days remaining to the fresh presidential election, IEBC Chair Wafula Chebukati has moved to the Supreme Court seeking clarity on the declaration of presidential results. In a certificate of urgency, Chebukati argues that the Supreme Court in its detailed judgment did not direct what the electoral body and its chair are required to do if upon verification the results captured in Forms 34B do not conform or tally with the results captured in Forms 34A. According to the Court of Appeal in the minor Kiai case, the results declared by the constituency returning officers are final, and any error noted in the statutory forms could only be corrected by an election court. Chebukati outlines that despite the Supreme Court agreeing with the minor Kiai case, the court emphatically stated that in the course of the verification, the numbers must add up. Chebukati therefore wants the Supreme Court to complete its directions and provide clarification on whether IEBC and its chair can correct errors in Forms 34B, where, if at all the results therein do not tally or conform with the results captured in the relevant Forms 34A. Chebukati also seeks to know which results the IEBC chair ought to lawfully declare if the verification exercise reveals that the results captured in Forms 34B do not tally or conform with the results captured in the relevant Forms 34A. The electoral body wants the court to expeditiously determine the matter, as its finding will be relevant for the purposes of the fresh presidential elections scheduled for October 26, 2017. Meanwhile, former Bungoma senatorial candidate Juma Mukwana has petitioned the High Court seeking to have IEBC stopped from using electronic system of voting during elections in Kenya. In a petition filed before the High Court, Mukwana wants Section 39 and 44 of the Elections Act declared unconstitutional.
That the system that should be developed within Kenya, an electronic, whatever system you want to use for voting, it should be simple, it should be accurate, and it should be verified by the voter.
He further claims that the KIM system is not simple, accurate, secure, and transparent as prescribed in the Constitution. And Mombasa High Court has upheld a petition filed by Mombasa Governor Ali Hassan Joho to have the state dismiss probe against him on grounds of malice and intimidations that aim to stop him from being elected into office. Delivering the ruling, Justice Eric Ogola accused the office of DPP of lacking independence in their decision to launch the probes, noting that the DPP's action had disregarded the public interest and the interest of the administration of justice.
This court hereby affirms that the petitioner's fundamental rights and freedoms enshrined in the Constitution of Kenya have been breached, violated, and abused by the respondents. For all the foregoing reasons, the petitioner's petition, dated 30th March 2017, as amended, is allowed as read.
Joho had challenged 7 counts, including the authenticity of his academic credentials and alleged use of abusive remarks against the presidency during the electioneering period. Elsewhere, Embakasi South Member of Parliament Mawadhe Julius has petitioned the court to accept and receive his response to an election petition filed against his election by Irshad Sumra. The Member of Parliament failed to respond to the petition within the required 7 days time frame and is seeking the court's indulgence. And a real estate dealer of Asian origin has been charged with defrauding a businessman 210 million shillings. Kirit Bagwadash Kanaba was arraigned before Kiambu Principal Magistrate Justice Kituku, where he denied obtaining the money through false pretense. The court heard that Bangwadash pretended that he was in a position to undertake renovation of apartments in Nyali, Mombasa, belonging to the complainant, a fact he knew was false. He was released on a cash bail of 5 million shillings with 2 sureties of similar amounts. Ben Chumba reporting for Scales of Justice.